All right, bon après-midi, tout le monde. Welcome to everyone who is here in the room, and welcome also to those who are watching online. And thank you to all of you for joining us today for this very important, it seems an understatement, opportunity to explore the crucial international human rights and international humanitarian law dimensions to the entrenched and longstanding conflict, violence, and occupation in Israel and the Occupied Palestinian Territory, a conversation which has obviously become ever more urgent and timely in the face of the devastating crisis in Israel and Gaza over the past 3 weeks. My name is Alex Neve. I'm a senior fellow at the Graduate School of Public and International Affairs and an adjunct professor of international human rights law here at the University of Ottawa. And I am very honored to be serving this afternoon as your moderator for this event. Before we begin, noting that we gather on the University of Ottawa campus for this important conversation, we pay respect to the Algonquin people, who are the traditional guardians of this land. We acknowledge their longstanding relationship with this territory, which remains unceded. We pay respect to all Indigenous peoples in this region from all nations across Canada who call Ottawa home. And we acknowledge the traditional knowledge keepers, both young and old, and we honor their courageous leaders, past, present, and future. We certainly hold all of that very close as we move into this discussion this afternoon about rights, justice, and security. Before I introduce our two speakers and turn things over to them for their comments, there's 4 brief points and observations I'd like to share. First, I want to acknowledge that for many people, including in this room, this conversation is far more than a mere academic consideration of the relevance, interpretation, and enforcement of international legal principles. It is deeply personal, and it has been for a very long time. The numbers, as we all know, rise daily and rapidly, but by last count, there are almost certainly now well over 9,000, approaching 10,000 people who have been killed in Gaza and Israel over the past 3 weeks, a staggering number of them children. And I realize there may very well be people among us who have friends, loved ones, colleagues, or acquaintances who were killed or taken hostage during the October 7th Hamas attack in southern Israel. There may be people among us who have friends, loved ones, colleagues, and acquaintances who have been killed, injured, or remain trapped in Gaza while Israeli forces proceed with their aerial bombardment and land invasion. There are people who have visited the lands and places that have been torn apart by violence over these past 3 weeks. So let us all be mindful of what others may be feeling, their sense of fear and anguish, and the lived realities they carry. Second, let us bring respect and understanding to today's discussion. We gain nothing, and we do not move forward with personal accusations and recriminations. Let us listen and learn, certainly from our two speakers, and also from each other. We want this to be an open and safe space for an exchange of views, including what may be at times sharply differing opinions, and to do so respectfully. And that will certainly very much guide how I moderate. Third, there has been such a contest of information and misinformation over the past 3 weeks, dramatically varying descriptions, justifications, analysis, and conclusions about the same incidents and the same attacks. Some undeniably true, others certainly fabricated. One of the obvious benefits of an initiative such as the Commission of Inquiry, you will hear more about in a moment, is that it offers a means for thorough inquiry and investigation, not rushed and determined by the pace and demands of social media. So let us all listen to the commissioners as they share their findings and recommendations with that in mind. And finally, there will be an opportunity at the close of their presentations to pose questions to the two commissioners. We will not be taking questions orally. Instead, if you have a question, please write it down on the pieces of paper that are soon to be distributed by colleagues here at the edges of the room. I will then pose your questions to our two speakers at the end of their presentations. I will endeavor to get through as many of the questions as time allows. I may have to group some together if they deal with a similar theme. Et certainement, vous pouvez poser des questions en anglais ou en français. So now on to the main event. We have a tremendous opportunity this afternoon to hear from two of the three commissioners serving with the United Nations Independent International Commission of Inquiry on the Occupied Palestinian Territory, including East Jerusalem and Israel. The Commission of Inquiry was established by the UN Human Rights Council in May of 2021 in response to grave concerns about violence and military operations at that time in Gaza and Israel. The Commission of Inquiry's mandate laid out in the Human Rights Council resolution is many paragraphs long, the central aspect of which is to investigate in the occupied Palestinian territory, including East Jerusalem, and in Israel, all alleged violations of international humanitarian law and all alleged violations and abuses of international human rights law leading up to and since the 13th of April, 2021, and all underlying root causes of recurrent tensions, instability, and protraction of conflict, including systematic discrimination and repression based on national, ethnic, racial, or religious identity. The Commission of Inquiry's work has continued over the past 2 years and very much continues now, with a mandate that clearly extends to what has taken place over the past 3 weeks. They have prepared and released 6 reports and papers, including the most recent one that was tabled at the UN General Assembly just this month. The Commission has also issued 3 press releases over the past 3 weeks, noting that, quote, all parties to the conflict in Israel and Gaza have shown reckless disregard for civilian life and must comply with international law to prevent atrocities from continuing. The 3 commissioners all have lengthy international careers in the realms of human rights and international justice, and by any measure possess impressive expertise and experience. You will have seen the biographies of the 2 commissioners who are here with us today when you registered, which I will only briefly summarize now. Navanethem Pillay, who is the chair of the Commission of Inquiry, served as the UN High Commissioner for Human Rights for 6 years, from 2008 to 2014, the 6th person to hold that role, and serving immediately after Canada's own Louise Arbour. She is currently serving as Judge Ad Hoc of the International Court of Justice in the Genocide Convention case brought against Myanmar by Gambia. In 1995, after the end of apartheid, she was appointed acting judge on the South African High Court. And in the same year, she was elected by the UN General Assembly to be a judge on the International Criminal Tribunal for Rwanda, where she served a total of 8 years, the last 4 as president. She subsequently served as a judge in the appeals chamber of the International Criminal Court for 5 years. Chris Sidoti is the former executive director of the International Service for Human Rights, and he has served as Australian Human Rights Commissioner, Australian Law Reform Commissioner, and founding director of the Australian Human Rights and Equal Opportunity Commission. His expertise in national human rights institutions and in international human rights law and mechanisms is widely recognized and sought after around the world. From 2017 to 2019, he served as one of the members of the United Nations Independent International Fact-Finding Mission on Myanmar. The third commissioner, Milun Kothari from India, is not with us today. So it is now my great pleasure and honor to hand things over to the two commissioners, beginning with Nave Pillay.
Thank you. This is on.
Yes, it should be.
Good afternoon, everyone. Yeah, as you saw me walking in with a huge smile, I wasn't looking at you, I was looking at the room. This is such a wonderful room with so much light. You know, I could almost be persuaded to become a student again, but not quite. Really, I'm so happy to see so many of you here. And thank you, Alex Neve, for organizing this. And I also want to pay my warm tribute to Michael Link, the distinguished special rapporteur for Palestine, who retired the year that our commission started. And we met him in Geneva, and he planted the seeds of how he thought we should proceed with this extensive mandate that we had been given. So we're deeply grateful to Michael Link as well. I'm sorry that because of illness, he couldn't participate today. All right, so back to your wonderful room. As a law student, I studied in a potato warehouse, which was the segregated university for non-white students. But long before me, there was Nelson Mandela, who studied by correspondence. And he says in his book that he was very fortunate that, you know, we all have to serve what we call articles of clerkship for 2 years. And he managed to secure one in a white firm. There were only white firms. And there were clear instructions to him not to use the cups they are for reserved for whites. He should bring his own tin mug for his tea. And also, if he was to succeed as a lawyer, he must know his place in society. 20 years later, I get my law degree from the potato warehouse, and I walk the streets looking for articles at white law firms. And they told me 3 things. One, well, you're a woman. What if you fall pregnant? And secondly, well, what does your father do? Is he a businessman? Can you bring a lot of business to the firm? And so it was sexual discrimination and class discrimination and race discrimination. And race being you're a non-white person and we can't have our white secretaries taking instructions from you. You know, I was comparing this 20 years after Mandela's experience. But today we have our wonderful constitution, we have our democracy, and I started here to have you believe in change, that change is possible no matter how difficult the circumstances. I have been to Israel and Gaza as the High Commissioner for Human Rights. In fact, the only High Commissioner for Human Rights who was invited to come on a full mission to Israel. And subsequently, after I'd retired, I spent a whole week with the students at Al-Haq University in Palestine. You could see the total depression. They just, you know, they were in deep, deep depression with seeing no light ahead. We went through that under apartheid. So you're going to hear from us lots of depressing stories. You're following it yourself. But remember that it's people who make change. Civil society makes change. Students make the change. So I'm very, very happy to be here. You heard a bit about this mandate. It's rather unique. I accepted before I saw the resolution. It's vast. I'm used to commissions of inquiry that had a single mandate. You know, go and investigate what happened at the Al-Aqsa Mosque, or investigate about the chopping of the olive trees. As soon as the olive harvest was ready, the settlers were alleged to have chopped down the harvest trees, olive trees. So it was specific episodes. They did the report and it was done in a year. Well, this commission has got no end date. It's not time bound. And that was one of the main grounds why the United States and Europe opposed the resolution setting up this commission, that it was not time bound. How can you have something that goes on forever, that's permanent? And so we responded at the assembly there in Geneva. The occupation doesn't have an end in sight. So this commission will continue as long as the occupation is there. And we also pointed out particularly to the US representative, the ambassador in Geneva, you did support, you yourself set up and are funding commissions that do not have a cutoff date. And the one being the III mechanism for the collection and safeguarding of evidence in respect of Syria. So that has no end date. Just pointing you the little bits of hypocrisies and how hollow their reasons are for objecting to this commission. But it was adopted by a majority, and the rule is once a resolution is adopted, those who oppose the resolution must support the commission. So we find this totally lacking. Those who oppose the commission are still opposing us in many ways, particularly with US Republicans interfering and cutting down the proposed staff contingent from 24 to 18 and passing a resolution here, your Congress resolution, directing Secretary of State Blinken to go and disband that Pillay Commission. I mean, it's so absurd. You know, no single country can go and disband a UN established body. But anyway, it goes on, and I keep raising the absurdity of one country having the power to interfere even in our continuing work. But you will learn from both Chris and I that we have a small team, but they've just worked wonders recently. We have a planned program of work. In each report we've submitted, there are 4 actually, not 6.
That's the conference room paper.
Oh, all right. Conference 4 reports to the UN. So it's planned work, and then suddenly we come here in August to deliver our report. The current report we just delivered was tracking all the accounts of atrocities and violence perpetrated mainly by Israel, but also the Palestinian authorities. All the violations, we track them for a lengthy period. It's about a 10-year period. And then suddenly that gives people an idea of what was going on before we have the 7th October Hamas attack on Israel. And so we began our report, delivery of our report in the 3rd committee on 24th of October by asking for a moment of silence as we express our sympathy with the families who have lost their lives in the Hamas attack and the ongoing counter-attack now from Israel. And we ask for the release of all hostages, and we ask for a cessation of hostilities. So 3 very clear messages came from us before we delivered our report. So if you want to know more about the work, the mandate of the commission, we can. So briefly, you know, as a former judge, it interested me that we had a mandate to investigate all the underlying root causes of the recurrent tensions, instability, and protraction of conflict. And so we established, from a very careful account of the facts on the ground, as well as international law, that the root cause of the conflict was the occupation itself, and we called for an end to the occupation. And we recommended that the General Assembly refer the question of the end to an occupation, the question of the lawfulness of the occupation to the International Court of Justice. And second question to be raised with the ICJ is, so what are the responsibilities of states if this is an unlawful occupation? Can they still continue to support the occupation militarily, politically, morally, as is happening now? So that matter is before the International Court of Justice, and I understand 56 states have already filed briefs in favor or against the question. So it's become a huge matter. The legal counsel, whom we just saw at the UN, said he himself has collected 4,000 documents to send to that court. So a massive volume of material before that court. We felt confident because if you are aware of the 2004 judgment of the International Court of Justice, where they dealt with the Wall case, really Chris is the expert on international law. So that's a good indication of what the court said, that the wall was illegal because it trespassed on Palestinian lands, and that building such a wall was actually laying the steps for permanency of occupation. So that's a law decision that's already there before us. So do watch out for the deliberations before that court on that matter. And we, of course, were really gratified that the majority of members of the General Assembly, 87 in total, supported that resolution, sending the matter to the International Court of Justice. Now, the International Court of Justice, as you know, was established by member states when they established the United Nations. It's a court accessible to states to resolve disputes and also to interpret international law. So it's their mechanism. So I am very surprised how strongly those who opposed it, including European countries, United States, Israel, of course, opposed a referral to the court that they established. But there you are, that's where that is. And as I said, now this October we find we have to switch from our planned work, which we did. So from 7th October, early in the morning, our team left what they were doing and immediately started collecting and safeguarding evidence, mainly from social media, on what's happening since 7th October. They tell me, the team, that some of this information on social media was disappearing as fast as it was posted. And so, but they managed to capture some of this. Eventually, we will, in accordance with our agreement with the prosecutor of the International Criminal Court, share this information, because that's what our mandate says: investigate these crimes and work with a judicial institution. It could be a national court that is willing to exercise universal jurisdiction and try suspected perpetrators, or it could be the International Criminal Court. We think that's the most likely, because the Rome Statute covers these crimes, and we're working closely with them. We haven't analyzed the information that we found. We're going to still be doing that. So let me stop there. We also have expanded our mandate, interpreted our mandate so that we cover what's happening to women and what's happening to children. So there are specific areas where we investigated those. We set out statistics and what we found in our report. So this commission is all about ensuring legal accountability. We want justice and accountability. And so therefore our investigations also include examining individual criminal responsibility and command responsibility. We've been asked to identify perpetrators, and we're already beginning to do so. The press release that Alex mentioned says clearly that we find that international crimes against humanity, war crimes are being committed right now as we speak by both sides in the conflict. in Gaza. So why don't I stop there and hand over to Chris? Yeah, thank you very much.
Thank you, Alex, and thank you, Navi. Like Alex, I start with acknowledging that we gather today on the land of the Algonquin people, and I pay my respects to their elders, past, present, and emerging, and thank them for their custodianship of this land that enables us to meet under such circumstances today, after care since time immemorial. I'm sorry that my country has not been as successful as yours in acknowledging that. Even though yours has still got a long way to go, ours has got even further. It's really nice being in Ottawa. I've been here a couple of times before, and it's a lovely city. The welcome has been a bit colder than I expected. You know, you Canadians live in a beautiful country, but by God, how do you cope with the weather? It's 37 in Sydney today. 3 when I got up this morning.
Probably the same in South Africa.
Yeah, exactly. Join us in the global south. I'd like to very briefly just introduce you to our 4 reports, plus the supporting document that went with one of them, to give some idea of the ground that we've covered already and leading into where we go from here. As Navi has said, we were established and appointed midway through 2021, and we report each June to the Human Rights Council and every October to the General Assembly. One of that long list of terms of reference that Alex referred to was to review past reports of United Nations mechanisms dealing with Israel and Palestine. And so we decided that we would focus on that for our first report to the Human Rights Council. I can say that from my point of view, that was about the most boring of the terms of reference, and so I wanted to get rid of it quick smart. So we look back over the past and we try to draw out the common themes of reports that had been done by commissions of inquiries. There have been 3 or 4 previously, all dealing with Gaza. None of them had actually dealt with the West Bank, including East Jerusalem, or with Israel. There have been special rapporteurs going back maybe 20 years, reporting like we do now, twice a year. So we reviewed those reports. Those special rapporteurs too only dealt with the Occupied Palestinian Territory, and so only part of our mandate. Treaty bodies have been reporting for a long time in relation to those treaties that Israel has acceded to or ratified, and more recently, in relation to the great majority of human rights treaties which have been ratified by the State of Palestine over the last 10 years. So there is a lot of documentation that we had an opportunity to review, and we were looking at it very much from the perspective of our own terms of reference, which required us to identify underlying root causes of the protracted conflict and make recommendations in relation to those. Our first report, drawing from all this work done previously, drew attention to 2 prominent or predominant even underlying root causes. The first was the protracted occupation since 1967, and the second was entrenched discrimination. We reported next, 3 months later, to the General Assembly, October last year. And in that report, we took up one of those 2 underlying issues, the question of occupation. We're a legally based body. And so for us, it was a matter of undertaking the legal analysis of the experience of occupation. For us, our starting point is to gather evidence from individual witnesses or victims, but also from experts, from documentation and so forth. And we examined the question of occupation, and particularly the lawfulness or otherwise of occupation, in the context of all of this material that we gathered. we came to the conclusion that the occupation is now unlawful. We did not address the question of whether it was unlawful in 1967 when it began. We felt that that was a related but a second question, and really beyond our capacity in the time we had available to prepare this report. And so we focused not on 1967 when it began, but on now. And the conclusion was, whether it began lawfully or not, it had become unlawful because it had become permanent, was associated with what we saw as clear intention to permanently hold and control the land that had been occupied. And as Navi has mentioned, that examination on our part resulted in the recommendation for this reference to the International Court of Justice. As enormously eminent as our chair is, the others of us are not quite so eminent by any means, and we're just a commission of inquiry. We are not as authoritative as the International Court of Justice. And our recommendation, therefore, was that the most authoritative judicial mechanism within the international legal system should be asked to examine this question and express a view on it. And we were very pleased. Actually, we were stunned that the General Assembly actually acted on that within 6 weeks. That's not really typical of the United Nations. So pleased and surprised that there was a very quick response. Our third report to the Human Rights Council in June this year looked at the increasing restriction of civil society space within all parts of the territories that we were mandated to examine. We looked, therefore, within Israel, in the West Bank, including East Jerusalem, and in Gaza. And we found strong evidence that led us to the conclusion that within all three territories, civil society space was being seriously restricted, mainly for reasons associated with politics, the politics of the jurisdictions, in trying to prevent the expression of opposition and oppositional activity by human rights defenders and civil society activists generally. In the case of Israel, the constriction was principally related to those individuals and organisations that were most critical of Israeli governmental policy in relation to Palestinians generally and the occupation specifically. In the case of the West Bank, the restrictions were primarily directed towards those who were critical of the Palestinian Authority and exercising democratic rights of assembly, association, and expression as civil society activists and human rights defenders who were critical of the Palestinian Authority. We examined in particular the killing of a civil society activist, Nizar Banat, at the hands of the Palestinian security officials. Banat was basically beaten to death, having previously had periods of detention because of his activism and his opposition to Palestinian Authority. And his death in June 2021 was followed by demonstrations by those who were similarly human rights defenders and civil society activists, and those demonstrations were violently suppressed by the Palestinian Authority's security services. Under a great deal of pressure, a number of officials of the Palestinian Authority were charged with his murder, but now 2 years later, that trial essentially has gone nowhere. So the case of Nizar Banat was, for us, a case study of what those who oppose the political controllers of the West Bank do to those, what those who control the West Bank do to those who oppose that control in the highly constricted political space. You know, a space where since 2006, there have been no elections. We also looked at a for us, a disturbingly growing trend towards cultural repression in the West Bank. And that is especially associated with individuals and artistic groups and artistic centres that are or are perceived to be associated with gay, lesbian, bisexual, transgender people. So individual performers who are seen as being gay, lesbian, or transgender, cultural spaces where theatrical events or artistic exhibitions are expressions of that community have been attacked and increasingly restricted and closed down. Gaza, under the Hamas entity, is a worse situation than on the West Bank. And there, any form of political activism is extremely difficult. We looked in particular at the case of one person, an artist, who was expressing political disagreement critical of the authorities there, and who was arrested and imprisoned and tortured very seriously, and now is silent for fear of continuing his activism. So the picture generally was a very sobering picture of controlling authorities in all three territorial entities who were hostile to the expression of opposition and constricted the opportunities for that by individual human rights defenders, by human rights organisations, civil society activists, and cultural or artistic expressors. Our report to the General Assembly that was released 2 weeks ago examines the use of force. We saw the use of force as being closely associated with the question of occupation. Again, we looked at this question in all of the territorial areas within our mandate and pointed again to deficiencies among all of those who are exercising governmental or governmental-like authority. In the case of Israel, we saw that demonstrators generally, but particularly those who were demonstrating in support of Palestinian rights, were subjected to harsh treatment. We were, again, particularly concerned at the restrictions of those who were critical of governmental policy. There certainly appeared to be a stronger targeting of Palestinian citizens of Israel than of other citizens of Israel. On the West Bank, we looked at the situation first within the legal context of law enforcement. At that time, and I think probably still now, the appropriate legal framework in which to understand what is happening in the West Bank is the law enforcement framework. The situation in the West Bank may be approaching the threshold of conflict or hostilities, armed hostilities, but certainly had not done so more recently. And within the law enforcement framework, we found excessive use of force or use of excessive force against demonstrators, and were especially concerned at the level of force used against stone-throwing young children, principally boys, teenagers, and against journalists. Focusing on those separately for a moment. Stone throwing is dangerous. But the stone throwers, who are generally 13, 14, 15-year-old boys, are confronted by heavily armed, heavily armoured soldiers using highly dangerous or lethal weaponry against them. Thus, the very high number of deaths of teenage stone throwers. We tried to identify what damage was being done by the stone throwers. We could only identify one Israeli soldier who in recent years has been killed or seriously injured by the use of a stone or rock, And that it was a death, and that death occurred not in the context of a demonstration with stone throwing, but rather the dropping of a large block of stone from 2 or 3 stories up on top of a soldier who was below. But that was the only incident that we could find reported where an Israeli soldier had suffered, and it was not in the context of stone throwing by demonstrators. One of the issues in law enforcement is that the use of lethal or potentially lethal force is only lawful in a situation to prevent an imminent threat to human life or of serious injury to a person. And when we looked at the consequences of stone throwing, it was difficult to see that those contexts met that legal test of imminent threat to human life or serious human injury. And so we came to the conclusion that in those contexts, the use of force was excessive and disproportionate to the threat that was being imposed. The situation in Gaza we considered to meet the criteria necessary to establish a situation of armed conflict. And so the applicable law was different. Human rights law applies to law enforcement. In the case of armed conflict, we're talking about international humanitarian law and human rights law coexisting. We had no doubt, and we said, that the indiscriminate firing of rockets or other forms of projectile from Gaza by Palestinian armed groups was a war crime, because they are fired indiscriminately at population centres, and that is prohibited by international law and is a war crime. We also looked at the issue of Israeli periodic bombardments of Gaza, and there we had to apply the tests of the use of violence within a war context. And so the tests of discrimination between civilians and non-civilians, necessity, proportionality, precaution, and so forth. And we found that in a number of the incidents that we examined, those criteria were not met. And so the use of force under international law was excessive. The picture of the use of force was extremely troubling. This report was completed in August, so 2 months before the most recent events. But the principles, the legal principles that were discussed in the report are the principles that are directly applicable now. We're talking about a situation of armed conflict. The law of wars applies. Civilians may not be directly targeted or killed as a result of recklessness in the use of force. The criteria of discrimination, proportionality, necessity, lawful military objective, precaution, all these apply, and they form the basis of judgment. Navi has mentioned how we already have moved our focus onto the current events. Sadly for us, only 2 weeks beforehand, we planned our work program for the next 2 years. Didn't last long. So we're focusing now on the current events, and those principles that we articulated in that last report are the principles upon which we will be moving now. Navi just bunged a piece of paper under my nose saying self-defense.
You didn't use the 2 words. Yeah.
Because I haven't used the 2 words. The issue of self-defense in international law is a complicated issue to which there are not easy answers, but we're hearing a lot about that at the moment, and we are generally hearing about self-defense in a way that does not actually match what the law says. Article 51 of the UN Charter gives a state a right to take military action to defend itself until such time as the Security Council acts. International law, unfortunately, does not abolish war. It'd be great if it did. It doesn't abolish war, but it makes the use of force legitimate in certain limited circumstances. Article 51, however, relates to an attack on a state by another state. This was said by the International Court of Justice in its advisory opinion in 2004 on the wall, that to attract the protection or the legitimation under Article 51 needs to mean attack upon one state by another state. So it's very difficult to present the current situation as one in which Article 51 applies, in spite of all the loose language that is used. One of, I keep calling it, bitter ironies of the current situation is if the State of Israel recognised the State of Palestine and the international borders of the State of Palestine, then the State of Israel probably could have used Article 51 and self-defence to legitimate its actions. Not the proportionality questions, I'm just talking about legitimate the use of force. But it hasn't recognised the State of Palestine, so it doesn't seem to apply. I remember from 40 or 50 years ago, having it drummed into me that humans have rights, states have obligations. Human rights only apply to humans, and in relation to those, states have not rights, but obligations. And I think that is the appropriate way to look at things. It is not a matter of the right to self-defence. It is the matter of the obligation of every state or state-like entity, and I can include Hamas as a governmental-like entity exercising governmental-like authority within the area of Gaza. I include them. The primary obligation of a state or state-like entity is the protection of civilians under its authority or its control. In relation to the State of Israel, that includes Israeli citizens. They are entitled to the protection of the State of Israel, which has a responsibility, an obligation to protect them. But it also applies to the Palestinians in Israel, in the West Bank, and in Gaza, particularly under the Fourth Geneva Convention, relating to the occupation of territory and the obligation on the occupier to protect the occupied population. For me, if we start looking at what has happened and is happening and will continue to happen, within the context of the obligation, the responsibility to protect civilians, a responsibility that lies on all of those who are active in the area, maybe we can start to see a way forward. But I can't see much interest in a way forward at the moment. Enough? Thanks.
So thank you very much to both Navi and Chris for that, that tremendous, sobering, important overview of the Commission's work over the past 2 years and the various themes and concerns that have been analyzed in your first reports. We are going to open up opportunity for people to pose questions. As I said initially, those will be taken in writing. So as you can see, there's people walking around with pieces of paper if you want to catch someone's eye or signal to them that you'd like to ask a question. And we already have some that have come in. So give me 2 seconds here just to do a little Actually, I'll start with one because Chris, you sort of ended with international law and its application in this context, focusing in particular on self-defense. But let's broaden that. A question here is, how is international law applied to terrorist organizations like Hamas?
It applies in full. Just as an aside, and I don't want to dwell too long on this, international law hasn't yet defined what terrorism is. There's no definition that's come out of the Security Council. There's no treaties. It's been argued backwards and forwards for years. We all know in our guts what terrorism is, but if you want to define it legally, cannot yet be done. So I try to avoid in relation to everybody that language simply because it doesn't have a legal definition. I mean, Hamas is a quasi-governmental entity which is exercising governmental-like responsibility in Gaza. And on that basis, it is as subject to international law as any other entity that is governmental or quasi-governmental. It's a non-state armed actor, another international legal term. But within the conflict of Gaza, it is subject to the law of war, international humanitarian law. And I've indicated already what I see as some of the key principles of that. You know, all those things I mentioned, not targeting civilians or injuring civilians through recklessness, proportionality, discriminating between civilians and non-civilians, combatants, and so forth. It's subject to that. As the quasi-governmental entity in Gaza, it's also subject to international human rights law. And that includes the treaties, because the state of Palestine has ratified or acceded to the human rights treaties. And so those treaties apply throughout Palestinian territory, which includes Gaza. So it's not just the Palestinian Authority that should be implementing the treaties, it's also the Hamas entity. So the short answer to the question, fully. How does international law apply to Hamas? Fully.
And of course, the very first cases that came before the International Criminal Court are prosecution of armed groups. Uganda, for instance, invited the ICC to investigate the Lord's Resistance Army. DRC, also militia who were tried there. So those were the first cases before the ICC.
All right, for our next question, let's bring it back close to home to Canada. Someone's wondering whether Canada opposed your commission, what's Canada's view has been on the reference on Israel-Palestine to the World Court and the International Criminal Court. And do you detect any change in Canada's policy now after October 7th and its aftermath?
Canada was not a member of the Human Rights Council. Yeah. So Canada was not a member of the Human Rights Council. The Human Rights Council is a subsidiary body of the General Assembly and has just 49 members. So Canada didn't cast a vote there, but in respect of the resolution passed here just a few days ago, no, Canada abstained.
Abstained last Friday.
Yeah.
It voted against the referral to the International Court of Justice.
And I guess embedded in there is whether you know anything about Canada's views on the International Criminal Court investigation.
No, I don't. I'll leave that question particularly to all the Canadians in the room.
How does Israel characterize the legal status of Gaza and the West Bank? Not as occupied territory, not as a legitimate state, so how?
I do. Ask some to Navi.
Well, they resist Gaza being referred to as occupied. You remember,
Yeah.
they gave up, they moved out of Gaza, so they don't like occupation, the word being attached to Gaza.
And I think the same applies. So far as Gaza is concerned, Israel considers that having withdrawn in 2005, it's no longer occupied. It doesn't consider the occupation on the West Bank as subject to the Fourth Geneva Convention. The argument is that Gaza and the West Bank are not part of the states, since Egypt and Jordan have now renounced claims to both. And so it is not the occupation of another state, is the argument that the State of Israel uses. Now, I have to say I don't find that legal argument very convincing. Far more significant than me not finding it convincing is that most other people don't find it convincing either, including the International Court of Justice. The ICJ in the 2004 case said it considered that the West Bank, including East Jerusalem, was occupied. That decision did not deal in depth with Gaza because it was about the wall that just goes around the West Bank. Israel considers that East Jerusalem and the Golan Heights have been annexed. No one else accepts that except the United States under the Trump administration, I think, finally accepted that, but essentially most of the world doesn't accept annexation either. So Israel stands pretty much alone in the legal views that it has adopted.
The fact is that they're exercising control over the borders. See, that's why they won't let us in, for instance. So they have control over the borders. They collect Palestinian taxes, which they're currently withholding. As soon as this resolution of referral to the ICJ was adopted, then Netanyahu said he's going to punish the Palestinian authorities for achieving that referral to the ICJ, and they're still withholding the taxes there. But more importantly, they control the supply of water, food, entry of life-saving humanitarian aid from the UN. So the control is an important factor to consider the authority of occupation.
We got a lot of questions here. International law requires states to respect each other's territorial integrity. Several states have since 1947 and do today Israel's territorial integrity militarily and politically. Many oppose the existence of Israel. What role, if any, does this violation of international law have as an underlying root cause of the violent conflict?
Yeah, I don't know whether that happens.
Maybe if I go first, we haven't looked at 1947 because this question really goes back to 1947 and the UN General Assembly decision on the partition of Mandate Palestine. There are certainly many people who urge us to go back and look at the 1947 resolution as a root cause. We just haven't done it yet, and we haven't decided whether we will go back that far or not. The only comment I would make is that since 1973, there has been no significant interstate warfare in relation to the existence of Israel. So that's now 50 years ago. And because that question of interstate warfare concerning Israel is so old and is not a contemporary issue, it really hasn't been something that we felt compelled to address immediately. Not a very satisfactory answer, but it's an answer that describes the practicality of trying to work with a mandate like what we've got.
Right. Given the stalemate at the UN Security Council, the ignored UN General Assembly resolution, what more should the UN do to meet your three asks, the ones you have presented to the General Assembly?
You know, out there on the street, the first thing that occurs to all of us is to say, stop it. Stop the killing, stop the violence. And so, as a human rights activist, I thought that inclusion of a call for a ceasefire will pass easily. But that debate took like 3 days in the General Assembly. They agreed on, it was humanitarian pause. The Secretary General told us when we met him that he thought that actually meant ceasefire, but the word ceasefire was being blocked, so they're settling for humanitarian pause. And as I said to you, we were already out with our press statement before October 10th, calling for a ceasefire or a cessation of hostilities. It's a first human rights concern. Stop killing people. Get to the negotiation table. But it seems an extremely difficult political hot potato in the UN, even to say stop killing each other. So the best we got is this humanitarian ceasefire. I think I'm right there. If you just look at the resolution adopted.
Want anything, Chris?
No, there's nothing to say.
All right, I'm going to translate one from French here. Does the mandate of your commission and international law that you are applying allow you to look into complicity in violations, complicity in violence against civilians, facilitating, encouraging, justifying, legitimating?
I think the mandate does allow us to do that. So this is interesting. You know, I also came to learn from you. You direct us to different areas. We were thinking of incitement to violence, also hate speech. Inciting violence would be one area we can look into, because the international crimes of persecution are very difficult. You know, I was sat on the Rwanda tribunal, needs a great deal of evidence for that. So we will consider attempts and aiding and abetting. I think we have an opening in being able to identify perpetrators. And if we identify individuals we suspect of committing serious crimes, we have to at least indicate what crimes that is. We're getting there. What do you think?
Je suis désolé que je dois répondre en anglais. The example, the referral to the International Court of Justice that we recommended and which the General Assembly made, as Navi said, asks the court to indicate what the obligations of third-party states are in the event of the occupation being found to be unlawful. So that question itself, the obligations of third-party states, indicates that both our mandate and international law has wide casting, potentially in relation to complicity, but certainly in relation to preventive action. And this relates to a number of international treaties where including the Fourth Geneva Convention, other state parties to the treaties have obligations to promote or enable the implementation of the treaty and to prevent violations of the treaty. So I think we will get the International Court of Justice making some very useful comments on this issue. And we as a Commission of Inquiry are waiting for the court's view on that question, and then we will seek to apply whatever the court decides through the work that we have under our terms of reference.
Would you consider the current conflict to be an international armed conflict or a non-international armed conflict? And how would that classification affect the legal analysis of international crimes?
Sure. Navi's looking at me. My reluctance is that I'm principally a human rights lawyer, not an international humanitarian law lawyer.
These students ask us difficult questions. No, but we had to interpret that for the Rwanda tribunal. It's an internal conflict.
Yeah.
And we applied international law. We said it applies. So I'm no good at labels. When do you classify it as an international armed conflict or an internal conflict? It's, you know, we are practitioners, so we see something in front of us, we see where the evidence is taking us. You, on the other hand, you know, you want clarity on which law applies where. So I don't have an answer except that we applied the law to an internal armed conflict in Rwanda.
I think it's not as simple as it sounds. You have to ask questions. Firstly, is Palestine a state? And secondly, is Hamas, even if Palestine is a state, acting on behalf of that state? My feeling on balance is that it would classify as a non-international armed conflict, but that's not an expert opinion. But you know, ultimately, however, and this is the bottom line that we do apply, and that, you know, I can claim some expertise on. Ultimately, the law is the law so far as armed conflict is concerned. We're talking about the conduct of hostilities, and that applies both to state and non-state actors. So I don't think in the end it makes that much difference to the conduct of hostilities. It may in relation to the characterization of the conflict, but I don't think it does in relation to the actual conduct of hostilities.
How can the two-state solution be preserved and implemented after war ends, as emphasized by President Biden, Prime Minister Trudeau, and the whole world except Israel?
Well, that's a good question. That's our question too, as we see more and more almost total loss of faith in the feasibility of a two-state solution, because so much of land has been steadily taken away by the occupying force. This is what we documented in our more recent report and in our factual account of why we thought the matter should go before the ICJ. What's being done on the ground with regard to dispossession, the settlements, and so on. The UN still insists on the language, and many states told us in response to our report at the GA, we favor the two-state solution. It's become like a mantra that they repeat without recognizing that a lot has changed since that solution was first proposed. Is there really a distinct territorial space for Palestine to exercise statehood, is the question. Chris, you want to add?
Yeah, can I more controversially say, I don't know, and it's not the basic question. The basic question is the right of a people to self-determination. We have to deal with human rights, not the politics of a two-state solution, in my view. And the human rights issue is Article 1 of the ICCPR and ICESCA. Every people has a right to self-determination. So let's start from that, rather than hitch our wagon to any particular solution that the people may decide they want. The greater difficulty then, however, and I have to put this on the table, is how does any people exercise the right to self-determination in the context of the exercise of that right by another people? It's going to be a very challenging issue for lawyers and politicians in their respective spheres to deal with that question when they eventually get round to dealing with it. They put it off for 75 years. But let's go back to the beginning of human rights law and say every people is entitled to self-determination, to determine their own future economically, politically, socially, culturally.
So this next question is posed by someone who admits at the outset that it may be too technical, but here it is nonetheless. And this is going back to self-defense, Chris. With respect to Article 51 of the UN Charter and the inherent right to self-defense, do you see a change to the underlying customary rule to include self-defense against non-state actors? Thinking of post 9/11 and all of the statements about Israel's right to self-defense being made by European governments, I'm wondering how the ICJ might view this nowadays.
Yeah, that's a great question. Chris has been addressing this the past 2 weeks. And President Biden has promptly said, Israel has the right of self-defense. And Chris explained it on statehood. So this question raises other areas of concern.
My response would be not yet, and maybe never. You know, the customary international law is such a bugger to try to determine what it is and what it means. Jeez. And it grows so slowly. You know, I actually, back to human rights, I actually consider that the Universal Declaration of Human Rights is now part of customary international law. And a lot of other international lawyers will want to lynch me for even suggesting that. So customary international law is very hard to come to grips with. But I think in this instance, I think it is fairly clear. There is not yet the unanimity of international opinion, in spite of what European states may be saying, to be able to say this is now a principle, an obligation under customary international law. It may happen one day, but I don't think it's there yet.
Now, this is maybe a bit more of a practical question. How can those posting on social media ensure you are able to retrieve evidence? I'm assuming this is a reference to your comments about the ways in which your staff were able to, including by turning to social media, begin to retrieve and compile evidence, but also the accompanying concern that sometimes that social media was disappearing very quickly. So maybe this is a bit of a question from someone who's wondering if people, whether it's through social media or otherwise, if people feel they have evidence they want to be bringing to your attention, how do they go about doing so?
So clearly the Dominion servers have the power to remove things out. And I understand, I think one of our team gave the statistics, because this is overnight work they plunged into immediately. And they think that 45% of what they saved, downloaded and saved, is already deleted from the site. So that's the first thing they did. We constantly call for submissions. I have to tell you, one of the most strategic things we did is to hold public hearings. We held hearings in Jordan and Geneva. We brought people out from Israel and Palestine and Gaza. They gave evidence before us. We had a hearing on the Shireen Abu Akleh murder. We had a sister give evidence before us, as well as the journalist who was with her. So oral hearings and a call for submissions. We've already put out a call for submissions on the October 7th attack on the hospital. So we're constantly doing that. And, you know, I'm not checking what's coming electronically to us, but that's one of the means where we can keep check of material on social media that we feel may be removed either by the owners of the site, I think it's X now, or by the power that governments have to remove the material.
And people would be able to, I guess, find the contact information by going on to the UN Human Rights website and finding their way to the Commission of Inquiry.
That's right. So the material we're gathering now, we have to safeguard from public scrutiny because we're very conscious that it's be required by the prosecutor. You know, prosecutors don't like information out there. So we have an agreement with them to meet their standards. That's one. And secondly, we have to protect the identity of witnesses who give us information and specifically request, I don't want my identity known. So we're handling it very carefully. However, all other material is put on the website available for researchers and so on. For instance, all the reports we filed have a word limit. It has to be just 10,000 words. Really, what can you say in 10,000 words? And we have to do it. That's why the the October report has to be filed by August and limited to 10,000 words. So what do we do with all the other information that comes to us, which is invaluable and of wider concern, maybe of interest to courts? We make it accessible on our website.
So in hot pursuit to your reference to the International Criminal Court and the prosecutor, we have a question here which simply asks, how confident are you, be it at the International Criminal Court or elsewhere, that we will see eventual progress when it comes to accountability for human rights violations in Israel, Palestine?
You know, I might be more open with that answer at home or somewhere after having a meeting with the prosecutor. ICC. So I was a judge on that court. I was in the appeal section. And I feel good about the contribution there on the rights of victims. We use the word victims because we found that that was missing in the ad hoc tribunals of Rwanda and former Yugoslavia. And we judges took the initiative of pressing the Security Council to provide rights for victims to appear in the court, for the rights of victims to have reparation. So a lot has been done in that court. And I, for instance, appreciated that victims may want a perpetrator to be charged on a very serious crime, and they find that hasn't happened. The militia leader of DRC was charged only for recruiting children. And yet they had masses of evidence on sexual violence. All these issues are addressed if you give victims a say in the courtroom. A lot of progress done there. And you would never have had an International Criminal Court today had it not been for pressure from civil society. We want that court. We want it to succeed. And therefore, I think all of us should keep a BDI to ensure that the prosecutor, whose responsibility it is to investigate serious crimes, that he does so. We've had 2 meetings with the prosecutor and the deputy prosecutor already. The deputy prosecutor is also a former judge from Fiji, whom I know. So how confident am I? Yeah, I believe nothing happens without civil society pressure. So do keep a watch on it and keep asking questions, as we will do. The Commission will do that as well, because we have an opportunity to meet the prosecutor at that level. How confident are you? You want to venture an answer there?
I agree with Navi.
All right, we've only got a few minutes left and I've still got about 12 or 15 questions. So I'm
Oh.
unfortunately not able to get to all of them, but let me try. I've tried to pick three, which I think kind of try to take us in slightly different directions. The first is, under international law, how will the Commission look at the way that Hamas failed to protect Gaza civilians by triggering a certain attack by Israel?
Well, I think we made clear that we, based on our initial investigation, say that we think war crimes have already been committed there by Hamas. Very clear. Now we need to gather a lot more information. Failing to protect civilians, yes, that's an obligation by state parties. So failing to safeguard will be one of the elements of the crimes that we think are being committed there by Hamas.
With reference to, you've noted that your recommendation around the ICJ reference was taken up quickly by the General Assembly and is going ahead. What do you see as the potential impact of an ICJ decision on the ongoing occupation?
Chris has a standard, very good answer there, but mine is, I can't tell you how many times ordinary people just fed up with the UN and all their rhetoric and talk, just come up to me on the street. So what's the victory? What's the point? What will the court do after that? Because they know very well that the ICJ's decisions are not always implemented by states concerned. These are the mechanisms we have. And this is the first time we've got that far to have this entire occupation examined by the court. And that's why I recounted to you that we took their own expositions of the law in the Wall case and applied it to occupation. So that's a drawback. There has to be implementation. And that is what's not happening in respect of all the other wonderful treaties and conventions that the member states pass, and then they themselves don't implement them. As Chris said, we are the rights holders, they are the duty bearers, the states, I mean. So the duty is on them to implement. What we have now, which we didn't have in my time growing up, and which didn't happen because states woke up one day and decided we must do more for human rights protection. No, it happens steadily because of civil society pressure. And that kind of pressure resulted in the Universal Periodic Review in the Human Rights Council, where states themselves have accepted to have their human rights records scrutinized by themselves, and then they make recommendations to themselves. But who participates in that process is the High Commissioner for Human Rights, who gathered information from all the UN agencies, as well as 58, probably now 60 special rapporteurs. You've heard of that. These are independent experts who focus on particular issues. We never had these mechanisms for accountability and to get states to move on adopting this. When I was High Commissioner, United States received more than 200 recommendations from other states, for instance. So no state escapes that level of scrutiny. I'm not saying that they implement all of them, but they take the whole process seriously, I have to say, they do. Foreign ministers come from their countries when their state is being examined. And why it's accepted is it's not a process of naming and shaming, which is what NGOs, I come from the NGOs, which is what NGOs do. We just want to shame the state. This process thinks of better ways to persuade and also assist. So the High Commissioner's office sets up offices in most of these areas to help them pass laws, to help them train people, whether it's judges, police, on domestic violence, just all kinds of issues, to implement those. So a lot is being done And I encourage you to use those mechanisms in respect of your country or other countries you are looking at. Send in those submissions to the Office of the High Commissioner for Human Rights.
Can I just add one thing? The 2004 advisory opinion on the wall was rejected by the State of Israel, and so it was not implemented. Advisory opinions are, as the name says, advisory. They're not binding decisions. Israel rejected it and didn't act on it. The bite in the current reference is the last part. What is the obligation, or what are the obligations of third-party states if the occupation is found to be unlawful? The court was not asked that in 2004, but that's where the bite will be, because the advisory opinion will be for implementation not only by the State of Israel, but by third-party states. And that could see quite a significant shift in the nature of implementation following the opinion, depending what it says.
Right. All right, we're at 5:01, but I'm just going to slip in one last question because I think this picks up on something that really hasn't come up directly yet in any of the other questions. What would you say is the level or role of complicity of states such as Canada and the United States in promoting and supporting Israel's offensive? And does that in any way fall within your mandate?
So Chris's last answer, this is the first time we got that in. Not only prong one, give us the status of the occupation, but what are the responsibilities of states? So that is where we're going with looking at complicity. You know, there are very many other treaties. I'm thinking now of the Arms Treaty. And it was developing countries who fought really hard, including my country, South Africa, to add an amendment to that to direct arms producing companies, all of whom opposed that in amendment, including Norway. I mentioned the Scandinavian countries because we tend to look at them for high standards. So the amendment was that there must be due diligence to ensure that the arms you're selling are not being used against people, for instance, against civilians. Is that being implemented? It's not. So sometimes you have a good provision in the law, it's not being implemented. Then along comes civil society bringing their complaints back to the UN, mainly to the Human Rights Council, where that would come up, for instance, as a complaint against a state for violation of that clause. They would, for instance, produce evidence that these arms were used by Saudi Arabia against Yemen. I know that there was a commission of inquiry that documented that. So that's just an example of how we closing in terms of the law. And we have to work in cooperation with eyes on the ground, and that is civil society. The Office of the High Commissioner for Human Rights has offices all over. That's the importance. They had an office in Ramallah, and visas have now been denied to all international staff. So suddenly a well-functioning, huge office has to shut down. There are national staff there, and UN staff are operating elsewhere. So these are all what I call eyes and ears looking at lack of implementation.
And just a short answer for me, we haven't looked at this yet, so I'm not talking about anything specific because we haven't examined it. But as I understand the international law of complicity, it requires some specific action and not just words to reach the threshold for complicity. It's got to be some action that actively supports the commission of an international crime. But we haven't looked at it, and we haven't even looked at what the jurisprudence is around complicity at this point. It's just my understanding. So it certainly would fall within the terms of reference, but whether the legal test can be met is something we'll examine when we can.
Well, Navi Pillay and Chris Sidoti, thank you immensely for this, for taking all of this time to share the incredibly important work that you, along with, of course, your colleague, Milun Kotari, and your incredible team working with you have been doing over these past 2 years, which was immensely important on October the 6th, is now obviously of incredibly urgent importance, given everything that has happened since October the 7th. I know it's been very illuminating for all of us to hear about the range of challenges, legal issues, practical considerations, and emotional considerations that you're working through. But if there ever has been a time when all of us need to marshal all of the energy possible, and I know how many times, Navi, you've brought back that reference of, you know, the power of people and civil society and speaking out to convey that message of this must stop. I think, as you put it very, very succinctly. But also, as we've seen, that international law, those incredibly important, very relevant and germane international human rights and humanitarian laws must truly come to the fore and govern how this crisis is resolved. This is that time, and your work is shining such an important light on that. So on behalf of everyone, thank you so much.
Thank you. Thank you
being
for
here
your
with us.
question.